Yes, why don't we?
So, good morning, everyone. My name is Salzberger. I'm Barzilai, and I'm the director of the study of the rule of law under certain conditions. I welcome you. Professor Barzilai, the dean, is not feeling well. He might join us later. At the moment, he is not here, and unfortunately, this morning we did almost a one-man show. And a man who had a sleepless night because his dog passed away. Oh. But he had a good life, a long life. So I suggest that instead of a kind of greetings, we will make a short round of introduction. And everyone will say a few words about himself, research, herself.
Okay, my name is Amr Rahman. I'm from the PI in the Minerva Center. My areas are public law, which include mainly constitutional law and administrative law, Israeli and comparative, but also international law to a degree. In terms of the Minerva activities, I do theories of regulation, including regulation of extreme conditions. And I also look into issues of cyber, related to cyber. That's my main role here.
My name is Prof. I'm currently a PhD candidate in linguistics. Actually, I'm academic. I'm a practitioner, academic disguise. I'm part of the general. I like his position of the head of the operational branch in the Gittleman. I've also been the Gittleman prosecutor for the West Bank. We believe applied to the Air Force, we applied to the Intelligence Directorate, Technology Statistics Directorate. I've been around both and contribute to my work that I'm presenting. Actually, the part of my PhD study, some IHL issue, question of motives, affecting the legality of decision. I'll speak about it. Looking forward.
I'm Michal. I'm the academic coordinator of the center. My background is urban planning and geography, and then I studied law. In the middle, I was doing my PhD on conflict resolution. And here I'm working a little bit on part of the research of the Center of Regulation for Earthquake Preparedness.
I'm Ilan. I'm originally from around here, but I'm a PhD student at UCL. I research the protection and regulation of foreign investments in times of stability, so it's sort of half and half kind of research between foreign investment law and IHL. What I will be presenting today also represents a small fraction of my broader research, and I also practice in London a little bit when I get around to it, and that is it.
My name is Anna Idit. I'm a PhD candidate at City University in London. My research, the main research question, it's not the title per se, is whether the law for conflict, international humanitarian law, is or is not out of step with unmanned weapons and technology. So I'm trying to address the normative and conceptual challenges, moral and legal complexities that arise in this context. I'm a qualified lawyer in Greece. I'm not practicing at the moment in my business. And I've worked for a little bit with the International Criminal Court on the field. Here my presentation will be, it's a part of my thesis, which is the practice I'm looking at, the use of drones in the counter-terrorist contexts, that of the US and Israel. So,
You mean
yeah, I hope.
focusing on issues related to the vehicles themselves, or the issues of automation and autonomous activity?
It's the way I'm focusing on the law and the methodological, let's say, approaches, the structural approaches to the law. What's the foundational structure and the norms, the normative basis, what the rules, what kind of norms the rules reflect, the law for conflict, and how, and I'm looking at the tension between the new technologies.
I'm just asking with respect to technology. Is the technology related to
To the unmanned, not the not automation.
not automation, autonomous decision making? Right?
No.
My name is Barbara. I'm from Munich, Germany. Originally lived in England for a couple of years and then I'm doing my PhD at the University of Frankfurt. I'm in my second year, changed the title a couple of times for data reasons. So I hope I'm not running down the same one background once more. But I think the PhD thesis is going to be on the same subject as the paper I present here, which is counterterrorism in authoritarian systems, on the example of Russia and China. That's basically what I'm looking at in terms of framing and strategy. And I haven't quite set up the structure for the PhD yet, which is largely going to depend on whether I'm actually able to go to China and Russia and do some research, or whether I have to stay on the secondary sources level, which would affect the quality of the research I can do, and therefore affect the kinds of questions I can answer.
But it's primarily political science, right?
Yes, my background is in political science. I also studied psychology and sinology. So I know a little bit more about China than I do about Russia. So that's kind of my background.
I'm Idit, Shafran Gittleman. I'm also a PhD student at Ilan University. I finished my dissertation a few months ago. I wrote thanks.
The world looks different after you do
It will look after the approval of it. Still, like,
that's
yeah, it's a fake minute, but
technical.
yeah.
It's technical.
Yeah.
Once you said me.
I wrote about questions of ethics of war, more specifically of partiality during war. My background is actually philosophy, and my first degree in law. And I'm going to present here a paper which is not a part of my dissertation, questioning the duty of country to invest financial resources
In civilians,
in civilians among the enemy, among other countries.
generally,
Yeah.
locally.
I just took my first sentence of the presentation.
It's a way to start.
And I'm studying postdoc next year at the big university in the Minerva project, and I'm also a researcher at the Visual Democracy Institute.
Hi, I'm Ilan Rosenthal. I think I've been in touch directly with each and every one via the process of getting here. I'm director of research of two projects here, Terrorism and Belligerency and Cyber under extreme conditions. As part of that, I'm doing a PhD in the Hebrew University of Jerusalem about the lack of competence, which is what I'm going to present here next week on Wednesday.
I'm dealing with a lot of issues related to your paper from a different angle. And prior to that, I worked 5 years at the Israel Democracy Institute and was a researcher in the Terrorism and Democracy project. And just because I'm very enthusiastic about this issue, I'm also the chairman of ALMA, the Association for the Promotion of International Humanitarian Law, a local NGO that deals with promoting the knowledge and understanding of IHL, mainly in Israel, but also abroad. And here we are basically starting a workshop that we've worked on for a very long time, and we have to say that when we started, we sent the open call. We weren't even close to hope that this would be the end outcome, or the researchers, the papers that we received, and the more prominent researchers that will come to respond and provide guest lectures, has basically put this workshop in a place where basically I defined it that I would actually like to join it even if I wasn't running it, which for me is basically the best way to actually acknowledge that this is a good program in my. So I want to thank you all for coming, and thank you.
So I'm Salzberger. My fields are legal theory, economic analysis of law, and legal ethics, and the Minerva Center, which exists for the last 5 years, is a specific project that deals with the questions of the rule of law under extreme conditions. We talk about 3 types of extreme conditions. This workshop, of course, belongs to only one type of belligerencies and terror, but we also inquire natural and man-made disasters, as well as financial and political meltdowns, which is the most problematic category of extreme conditions. And of course, since we are anchored in the law faculty, although this is an interdisciplinary center, we try to examine the questions of the rule of law during extreme conditions from normative, positive perspective, comparative perspective. And I will try to put my little lecture on basically informative lecture on counterterrorism law in Israel in this framework of some of the theoretical questions that we asked at the Minerva Center. I want to thank Idit for organizing this workshop, which is funded by a special grant of the Minerva Foundation, which is an offspring of Max Planck Society, and establishes in Israel research centers and support ongoing research in those centers. And I hope that we all have a very good workshop. And this is really the kind of the right size, the right format to get to know each other, to exchange ideas. And I hope that by the end of is it next week or the week following we'll all be a nice group that will also exchange ideas and keep in touch in the future. I think we should also thank Lily for her administrative help with regard to coordinating this workshop. And as I said, I want to talk a little bit for Israelis. It might be a little bit boring, but I think it's a good thing to talk at the beginning about the Israeli framework, legal framework of counterterrorism law, especially in the light of the fact that this is a topic that is becoming very relevant in many other countries which didn't suffer or which didn't have such a phenomena that's very similar to what we have here for the last 100 years, basically. So European countries, France, Germany, other countries are now examining the counterterrorism law. We had an earlier wave prompted by 9/11 in which the Americans changed significantly their counterterrorism law as well as the British. And what I want to say in the beginning is that basically what you are experiencing in Europe is something that basically almost going to celebrate a millennium in this part of the land, in Israel, Palestine. Terror activities began. Terror activities began in 1920s, which is also an interesting phenomena after the British conquest of Palestine and the Balfour Declaration. It began with massive attacks on Jews in all British Mandatory Palestine, where more than 100 Jews in Hebron, basically eliminating the Jewish presence there. This was prompted by we tend to view terrorism in Israel as a Palestinian and Arab phenomena. By the way, all terrorist activities in the last 100 years, or virtually almost all terrorist activities, are on the background of Palestinian-Israeli conflict or Arab-Israeli conflict. But there's also Jewish terrorism, which we shouldn't undermine. And following the 1920s, Etzel organization, which is a terrorist organization, was established. Began operating with terror activities against Arab population as retaliation activities, and afterwards also against, from 1939, against the British. And this prompted basically one of the legs of the counterterrorism law that still is in force today, which is the Defense Emergency Regulation that the British enacted in 1939 and amended in 1944. A second leg of counterterrorism law in Israel, which I will elaborate a little bit, is the Prevention of Terrorism Act, which was enacted very shortly, a few months after the establishment of the State of Israel, over one weekend. And this was following the assassination of the UN envoy to this area, Volker Bernadot, by an offspring of the Etzel terror organization called Lehi, offspring that was established because the Etzel during the Second World War decided not to fight the Brits, and an offspring formed in intention to kick the Brits out of here. And this Prevention of Terrorism Act was used harshly and basically eliminated within a few months this Jewish terror organization, Lehi. Then we have in the 50s and the early 60s terror that was mainly by infiltrators from the Arab neighboring countries after the setup of the borders following the Independence War. And terror activity changed significantly following the occupation of the West Bank and Gaza in the 1967 war, which brought terror, many terror activities from within or from within the occupied territories. And what we also have an interesting phenomenon which is connected to today's terrorism is the internalization of terrorism with the establishment of the PLO in 1964, and its connection with other terror organizations like the Bader-Meinhof Group and other organizations. We have another period of Jewish terrorism in the 1980s, Jewish Underground and other terror organizations. And we have a change of terror format following the Oslo Accords in 1994, where unfortunately and ironically, the accord between Israel and PLO brought about massive terror attacks and a change of structure of the terror attacks to suicide bombers. And the period between 1994 and 2000 was a period in which most of terror victims, the highest number of terror victims per year, were counted in this area. And in 2007, Israel withdrew from Gaza, and their terror attacks of what is perceived by Israelis as terrorism changed its nature from suicide attacks, to launching of rockets. We can talk about this, whether this is considered a terrorist attack. And we have, in the last 2 years, also an interesting mode of change of what is perceived as terror activities, not anymore activities by terror organization, but still acts of terrors by individual, knives, running over, and retaliation by Jewish terrorists, what is termed in the Israeli news media price tag activities. So you see remnants of all these modes of terror, whether it's knives, running over, suicide bomber, and stuff like that in other countries as well. And therefore, I think the legal framework for the analysis of counterterrorism law in Israel might be of interest.
You know that the first suicide bomber was actually a Jew. Barzilai is the first person who went into it. He didn't explode himself, but he went into knowing that he would be killed.
We talk about statistically identified victims, but he killed and he shot and he didn't explode himself. Okay, we can talk about whether this is the same thing and would merit the same response. To put counterterrorism law in theoretical perspective, we basically distinguish between 3 different models with regard to counterterrorism law that operates in different countries, and these are not exclusive models, it's theoretical model, and I'm talking now on the positive level. We can talk later on which model is to be preferred. One model is business as usual, which means that no need for a real change of the law, of the rule of law under extreme condition, or under terror attack, or under terror period. We just amend regular legislation to face the problems, the new problems that are occurring. And the American Patriot Act is an example for that. The American Patriot Act was very cumbersome legislation that was enacted within a few months after 9/11, actually 3 or 4 months, but it is a regular legislation. It was supposed to end at the sunset clause, but it was extended upwards, and now it's regular part of legislation. We have Prevention of Terrorism Acts in Britain with new additions, last one from a few years ago. Again, these are part of the regular system of law. A different model, which is practiced in many countries, is emergency constitution. Emergency constitution means that if we face an extreme condition, we make a switch to different rules, different laws that come into effect, as well as different procedures for decision-making, especially rule-making, that is delegated usually from the parliament to the government. When this extreme condition or emergency is enforced for a very short period of time, harsh measures can be taken during this period, but when this period ends, we go back to normality. Emergency constitution originates from the Roman model. The Roman Republic had a procedure when anticipating war, they can appoint a dictator, abandoning all the regular procedural decision-making rules. The dictator can do whatever he always wants to do in order to achieve preparation for war or to fight the war. But after 6 months exactly, the dictator had to go home, and normality was restored, and there was a very, very detailed account of separation between emergency rule and regular rule. The Weimar Republic ended with such a declaration when the Nazis came to power because of emergency constitution, and this brought criticism of Carl Schmitt, for example, criticism on liberal democracy. If there is a person or a body that holds a switch to turn from normality to emergency, then of course the sovereignty is not within the people or within the legislator and so forth and so on. We see still emergency constitution even in the new Federal Republic of Germany constitution, but it's much more limited. This is a possible second model for handling emergency or extreme conditions. And the third model is stepping outside the rule of law. We have an emergency, we have extreme conditions, we don't have laws in order to look and tackle these extreme conditions, so we step outside completely the rule of law, trying to legitimize or legalize what was conducted ex post. And as I said, these are conceptual models, and in practice you see countries actually having combinations of these two models. For example, in the US, on one hand, there is hardly any emergency constitution, but business as usual model is very prevalent, as I explained, the Patriot Act, which is regular part of legislation. But on top of it, there is a notion of prerogative power of the president, who can, under emergency, basically do almost everything. So you have a combination of stepping outside the rule of law and business as usual. France, the same. The recent attacks in France in Paris prompted the entering into a force of emergency constitution. But in France, you have also Article 14 of the French Constitution, which basically enables the president unlimited power. And from my perspective, we can talk about it later, this is stepping outside the rule of law, even if the prerogative powers are expressly mentioned in the Constitution. So you have the combination of these two models. Israel, I think, can be characterized, and this is one, I will skip some of these slides, but we can talk about them later. I think also in international law, you can actually notice the three models. Laws of war are basically business as usual because these are laws that are always there. Okay, they are prescribed ex ante, and one of the questions that is going to discuss here is whether they are sufficient to anticipate various tactics or various technologies that were not thought about in advance. Derogation in international human rights law, in human rights treaty, are basically emergency equivalent to emergency constitution. Okay, there is an emergency, we cannot abide by the obligations that we took upon ourselves for a limited time, and therefore we derogate from the treaty, the European, the international, the American Treaty of Human Rights, and so forth and so on. And international practice is basically stepping outside the rule of law. If we look at what happened in Yugoslavia, if we look at what happened in Iraq, the coalition actually attacked both these places without legal authority as prescribed by the international law, rules, Security Council decisions, and so forth, on bypassing the rule of law and trying to legitimize or legalize this ex post. And so it's interesting to talk about these three models, and by the way, please feel free if you have questions, remarks, comments. We have a small group. It shouldn't be necessarily a lecture and then Q&A. Yes.
Yeah, I have a question on your sort of foundations, because as I said, I'm working with authoritarian systems, and in both cases, Russia and China, the rule of law is sort of contested. Would you define the rule of law as an existing condition of these models, or what would happen to these models if we didn't have a rule of law in the first place? Or could you just say?
Yeah, the rule of law is a foundation.
Okay.
The rule of law is a very, very complicated concept. Okay? I think there are two facets of the rule of law. The formal facet means that any use of authority by officials have to be grounded in laws, in norms, which are prospective, which is publicly publicly declared and published by a legislator or a body that makes especially mechanisms, so on and so forth on, and that individuals are free to do whatever they want to do unless they are prohibited by law to do something, which means that basically law covers every human activity, both of individuals and government. But this is only the formal facet of the rule of law, because under the formal facet, like in Russia and China, you can have, especially in China, not in Russia. In Russia, I think the problem is the gap between law in the books, law in action. In China, they don't accept even, they accept the formal facet of the rule of law, but under the formal facet of the rule of law, the prohibition on individuals are very, very massive, and the powers granted to the authority by law are also very, very broad. So we say that the substantive part of the rule of law is that even if something was given to the authority, power was given to the authority to do something, invalidating individual rights, it has to be curtailed, justified, and reviewed by a system of separation of powers, independent court, constitutional court, and so forth. So human rights, the protection of human rights, is part of the substantive facet of the rule of law. And of course, there, Russia and China are not very not performing very well. But yes, to the question, these categories are funded upon the foundation of the rule of law. And I must say that, as somebody doing law and economics, the quality of the rule of law, this is already a positive normative argument, the quality of the rule of law is the #1 predictor for success of society, not democracy. A country can be very successful in terms of GDP, macro indicators, happiness, if it maintains the rule of law, regardless of the question whether people elect their government. And therefore, we look at the rule of law as a very, very important and fundamental concept. And again, the concept is not agreed upon, definition of the concept is not agreed upon by everyone. So I give you a gist of the questions here. So maybe we'll save this to the end of the lecture. What characterizes Israel counterterrorism law is these factors. First of all, and this I think you can say the credit of the state of Israel, that it uses the combination of business as usual and emergency constitution, and it doesn't use the stepping outside the rule of law. Maybe there are one or two incidents in which the rule of law was stepped out, but we don't have this concept of prerogative power. We don't have a concept of a government or a person in charge that can do whatever he or she wants to do in order to tackle the emergency. We follow the rule, the thin or the formal layer of the rule of law. Every power of the government has to be granted by law, and it might be an emergency law, but by law. So we play around these two models. Constitution, emergency constitution on one hand, and business as usual on the other hand. A second feature, which is quite interesting, is that most of the legislation, most of the Israeli counterterrorism law is very old. We have the British defense regulations, as I mentioned, that were inherited by the state of Israel when Israel was established. We have the Prevention of Terrorism Act that was enacted by the interim government even before the first election in 1948. And until very recently, these were the main legal pillars of counterterrorism law. In 2005, there was an addition of financing terrorism, which I relate to later. But the tools, the legal tools, are quite old, and with the years, actually, the Israeli parliament abolished some of these powers. However, the Knesset just last month approved a new counterterrorism law, comprehensive, that will replace the old Prevention of Terrorism Act, as well as the Financing of Terrorism Act, and it will come into force on the 1st of November. So I will say a few things about the comparison between the new legislation. It's a massive legislation, so it's the first time the Israeli legislature really deals with the question. And it has some advantages, some disadvantages, which I will elaborate a little bit later. Basically, counterterrorism law comprises two main segments. One is a special penal code related or applied to terror activities, both individual activities, terror acts, and the organization of people into a terror organization, as well as administrative measures, on which I will talk in a second, that can be taken ex ante or ex post to the perceived terror threat. Another important component, I think maybe the most important component, and this relates exactly to the question of the rule of law and the question of the law in the books versus law in action. Another characteristic of Israeli counterterrorism law is a very massive involvement in the application of the law, scrutiny of the application of the law by the courts, which I think is a unique Israeli phenomenon. The courts in Israel can intervene even in the middle of a military operation and rule that this operation is illegal or suspend this operation, and the counterbalance of the courts on the usage of the draconic power that exists in the law is something very unique to Israel. You won't find it other countries. In the US, and this has both procedural and theoretical or philosophical reasons. Procedural because if you want, for example, to attack, to review or to attack a quick response activity of the American forces against terror, you have to apply first to a local federal court and then continue to the Court of Appeal and then continue to the Supreme Court. This will take years, and this makes it irrelevant anymore. The Israeli structure is such that you can approach on the spot, immediately, directly the Israeli Supreme Court, sitting as a High Court of Justice, and we talk about the background of this arrangement, and to get a relief within hours. So the court can really interfere with the actions of the government on the spot immediately, and therefore it has a real input into the outcome, policy outcome of the actions of the government. And this is the procedural explanation. The substantive explanation is that Israeli courts from the very beginning were willing to intervene also in government's action in times of emergency. Again, unlike, for example, American courts, in which there is a concept of deference. There is extreme conditions. We are not doing anything. We are deferring the power to the administration. And I think from a court intervention perspective, these are two pillars. And here I'm talking about the democratic world in general and not about situations in non-democratic countries, China, Russia. So I think these are the main characteristics of the Israeli counterterrorism law, and a few words about the two basic theoretical pillars, the emergency constitution. Okay? And again, what is interesting also is the difference between law in books as well as versus law in action. Okay? The emergency constitution in Israel, basically, from a theoretical perspective, is a very, very nice, from a democratic theory, arrangement. Okay? If there is an emergency, okay, the government, the Knesset, can declare a state of emergency, and if the Knesset is unable to convene for that purpose, the government can declare a state of emergency, which has to be approved by the government within 7 days. And this emergency declaration is in power for 1 year. Okay. And what does it mean, a state of emergency? basically two consequences. First consequence is that it brings into force pre-existing legislation that is valid only under a declaration of emergency. For example, the Prevention of Terrorism Act from 1948 is in force only when there is emergency. Or the Administrative Detention Law from 1979 is valid only during time of emergency. Emergency stops, then these laws are not in effect. And so there are various laws, and I'm not now talking about the most used one, the commodities and services, but there are various laws that are coming into effect when emergency is declared and are basically not in effect or not applicable when emergency is not. A second consequence of declarance of emergency is changing procedure of decision-making or rule-making, basically. Usually rule-making general norms are made by the Israeli parliament, the Knesset, 3 readings, deliberations, so forth and so on. During emergency power, the government has the power to legislate, even individual minister, to issue emergency regulation that basically can supersede any existing law, but these regulations are enforced up to a 3 months period. And if they are extended by the parliament, then it's regular legislation. If not, they expire. So, according to basic law, the government emergency regulation can impose neither retroactive punishment or no violation of human dignity, and they are subject to judicial review. And indeed, the court, the Israeli Supreme Court, from the very beginning of the state, said that it is willing to review the use of emergency powers, emergency regulation, and other aspects of it. First only on procedural grounds, but then later on also on substantive grounds.
Yeah. Just one comment here. A law can resist emergency regulation, any statute, resist emergency, it declares it.
Right.
So it's not any regulation, provided that the law doesn't.
Yeah, right.
And many laws do say that emergency regulations do not apply.
The Knesset law itself, basic law of the Knesset, is immune from emergency regulation. So, a good remark, because this shows you that basically it's the structure of emergency procedure is quite impressive on the books. It has a declaration of emergency, has basically checks and balances. It's not the government can declare emergency, it's Parliament to declare emergency. There is a limited period of time. There is a judicial review, even in emergencies specified by the law, and so on and so on. The problem that on the ground, law and actions, that the declaration of emergency was made in 1948 with the establishment of the state in the midst of the independence war, and basically was extended by the parliament, by the Knesset, every year since. So we are in a constant state of emergency since the establishment of the state. In 1999, the Association of Civil Rights in Israel petitioned the High Court of Justice, saying that this extension, of almost automatic extension of emergency, is against the substantive facet of the rule of law. And following criticism of the High Court of Justice, the government promised to update all legislation and to bring into date old legislation so that the declaration of emergency will be a ground for its abolishment. And we're still in this process. But the Prevention of Terrorism, the new Counterterrorism Act 2016, which I will talk about, is not contingent. This is one of the differences between the old Anti-Terrorism Act and the new one. The new one is not contingent on emergency declaration. Okay, so this is part of the government's response to the court remarks, criticism. Okay, we enacted now the Counterterrorism Act, but now the Counterterrorism Act in Israel is like the Patriot Act or Prevention of Terrorism Act. It is permanent legislation. So we can talk about it, whether this is a good or bad from a normative perspective development. A few words about the different pillars counterterrorism law. As I said, the older one is defense regulation, which were enacted by the Brits as a response to the mounting tension in Palestine. But we find it's quite interesting, and this is also an interesting area for comparative research. We found very similar emergency regulation in other disturbed parts of the world, which were held by the British before the Second World War. Cyprus has very similar regulation. Northern Ireland, very similar regulations. India and Pakistan, very similar, and still have, of course, very similar regulations. And again, the comparative perspective will be to show, will be try to see which country really repealed or changed or amended these regulations altogether. Israel did some amendments, but not very significant. We'll talk about in a second. For example, the power to deport within Israel was abolished. Now, what is interesting here, our terrorism problems are mainly or primarily or significantly focused in the occupied territories, and the British emergency regulations are in force in the occupied territories as well, because as Israel inherited them from the Brits, the Jordanian and the Egyptian inherited them from the Brits and didn't repeal them. So when Israel occupied in 1967 the West Bank and Gaza, the regulations were there as part of the municipal law. And unlike Israel proper, in which many of these regulations were changed, some of them abolished, the regulations are almost as their original version in the occupied territories. What does the emergency regulation include? They include a penal code for security-related offenses. Originally, the jurisdiction was by a military court. Originally, there was no appeal. This was changed in Israel in 1963. This was one of the amendments to the emergency regulation. In 1989, it was changed also with regard to the occupied territories following the petition of the Association of Civil Rights in Israel. And this is very important because these offenses that are included in the emergency regulation are very draconic. They have many offenses that have equivalent in the General Penal Code, but with much more severe maximum punishments, including death penalty, which doesn't exist in regular legislation in Israel. And they have also special offenses like membership or operation or expressing support in terror organization, which I will relate a little bit later. The defense emergency regulation, the penal code of the defense emergency regulation is actually not used in Israel for the last 50 years. Okay? Because it is a military code, it's a military system. If there is someone who is suspect terrorist activity within Israel, he or she will be tried according to the Prevention of Terrorism Act or according to the General Penal Code. There is no use almost in this penal code in Israel proper, but there is a use of this procedure and penal code in the occupied territories.
Actually, it was a court in law. It operated until the early 80s.
Yeah, very few cases.
Very few cases out there, but
It's also a legacy of the military regime that was in force until 1966. This the law court was active.
Yeah.
And during the 70s, it basically was. But you have the issue of Jerusalem, where technically speaking, Jerusalem is Israel, and Israeli law it is, but
it's only highlights every question in this very general survey can really prompt a long discussion, but thanks for the remarks. The emergency regulation, what is the more important part of this emergency regulation is administrative measures. First, the declaration of an organization as a terror organization, which is in the hands of the defense, Ministry of Defense, and very harsh measures which are not basically punitive, which are supposed to be preventive and are not decided by a proper court after due procedure and but by the administration. And these measures include deportations, for example. This was abolished in Israel, but still exists basically in occupied territories. Detention, again, detention, according to defense regulation, was abolished within Israel and replaced by the detention law from 1979, administrative detention law. But it still exists in the occupied territories. Movement restrictions used a lot during the military rule until 1966. House demolition, a very interesting story. I think there is somebody who's talking about house demolition, Brian. I saw the program. Yeah, I'm talking about it.
No, military detention,
Not house demolition, because house demolition is an interesting phenomenon that, because of court intervention in the 70s and 80s, the government, military basically, the army decided to stop using house demolition altogether. And we now see, following this lighter wave of terror attacks, but it's not suicide bombers or massive attacks by a terror organization. It's individual people that house demolition are utilized again, probably because of political reasons and not really military need. And we sense in the Supreme Court that there is a strong contingent of judges who say, well, we have to discuss whether the whole issue of house demolition is constitutional.
and under which condition? Under which condition?
Under which condition? No, even the power itself, some judges, maybe Mazouz, one of his remarks, and these are, it's always in the minority and remarks, but this means that the court is going to treat the question of house demolition quite soon and decide in a large panel whether this is a valid measure to be taken. Because house demolition, I'm mentioning here prevention and reaction. While administrative detention, you detain a person who is suspected in terror activity that is going to happen, this kind of prevention thing. To put house demolition, place house demolition, this is the reason I'm saying reaction here, but of course the argument is different. To say that house demolition is a preventive measure is not so easy. It is in the public rhetoric, or our very right-wing government rhetoric, the rhetoric of retaliation or retribution. Although formally what is presented to the court is that house demolition is a deterrence, meaning a deterrence need to enforce members of family of the potential terrorists not to carry the act and so forth, so on. And therefore, and according to the court, it can be used only as a deterrent and not as a punitive need. And we'll see developments in this regard. As I said, the Supreme Court was willing to review administrative measures taken on the basis of the defense regulations from the very beginning, from 1948, from 1949. Initially only with regard to the procedure, whether these administrative measures were taken in the right procedure prescribed by the law, due process and so forth and so on. But in the last 40 years, it also is willing to interfere substantively with the discretion of the administration or the Minister of Defense when such orders are issued. And even for that purpose, it created the common law of a special procedure rule. And this is due to the fact that in many such cases, when a person is detained and he appeals against or he applies for judicial review against his detention, the state argues, had we been able to disclose the evidence, we would have put this person to a regular trial, but we cannot disclose the evidence because this disclosure will affect state security, they are very, very classified evidence. And the state actually labels this evidence privileged according to the evidence ordinance. And therefore, the court cannot really examine the discretion of the authorities, whether this detention, deportation, or house demolition is justified. So the court already, as I said, 40 years ago, suggested a procedure according to which, basically an inquisitorial procedure, according to which, if the other party is willing, if the party applying for judicial review of this, the party that is detained, demolished, and deported is willing, and his lawyer is willing, the court will look at the evidence without their presence and decide on the merit according to the evidence. And this is a very interesting example of common law procedure that was created by the court. It was afterward adopted by the legislator. It is the procedure now in the 1979 administrative detention legislation, and also in the new anti-terrorism, counterterrorism law that is going to be enforced on the 1st of November. So this is quite an interesting development. I'll mention in a second again. We can talk about, again, law on the ground, law in action with regard to deportation. Similar story, Supreme Court decisions brought almost to stop, to the army to stop using deportation even as a preventive measure. And this is an interesting, again, for those who do comparative perspective research of what is the Israeli law, have to take into account also this input of the court, which actually curtails very, very significantly the usage of these draconic powers. Okay. A few words on the Prevention of Terrorism Act from 1949. Really a few words because this law will be repealed in 2 months. It was enacted, as I said, 5 days after the assassination of the Baron Bernadotte, and was used to eliminate Lehi within 3 months of its operation. Again, it includes also a penal section and administrative one. And what is interesting that until the 1980s, it was hardly utilized, or it was utilized only against Jewish terror groups, Lehi and alike. And in the 1980s, it was discovered by the government. In a very side affair of counterterrorism law. It was a time in which Israelis from the left wing started to negotiate with the PLO, had meetings with the PLO, and the government regarded the PLO as a terror organization, although it was declared as a terror organization only in 1986, which is quite interesting according to the Prevention of Terrorism Act. But it was declared as a terror organization in order to prevent Israelis meeting with PLO officials, and the threat of these Israelis was that they would be indicted according to the Prevention of Terrorism Act under the section of expressing support to a terror organization. So it's quite interesting that although Palestinian organizations were the main enemies of terror initiator, only in 1986 the PLO was declared a terror organization. Only in 1989 Hamas and Hezbollah were declared terror organization, and the Prevention of Terrorism Act was really not very instrumental in the actual fight against terrorism. And what we have in 2005 is the first time that the Israeli legislature is really intervening with a major comprehensive piece of legislation. And this legislation is a response to the internalization of terror activities and the very complicated financial aspects of funding, of supporting a terror organization. As I will not elaborate because again this law is going to be repealed once the new counterterrorism law. Yeah, incorporated into the new legislation. So what are the main points regarding the new counterterrorism law from 2016? First of all, and we can talk about it, it is in force permanently. It is regular legislation, i.e. adopting the business as usual model, as opposed to the old law, which was only in force during declaration of emergency. It has new legislation, so it has a very nice introductory sector, section 1, which says that all the powers used by the government according to the law should correspond to Israel's obligation to respect human rights in accordance with international law, which is quite interesting because it is a section that will give the courts much more leeway to review both the actual arrangements in the law and their application in certain specific circumstances. So this is, I think, an advantage of a modern legislation that it brings into effect international obligations, and we can talk about it. It's basically not natural. Our system is a dualistic system. Obligations of Israel according to international law, which are not incorporated by the Knesset, are not part of the municipal law. One can look at this section as actually incorporating those obligations into the Israeli municipal legal system. So it might be a very, very instrumental section. And another thing that can be said about the law, that it captures much broader activities under the roof of terror activity, terror organization. But it's much less draconic than the previous legislation in terms of the punishment, the maximum punishment, in terms of administrative measures regarding property, which I will say a word in a second. And to the credit of the government, one can say that the Minister of Justice or the Knesset basically enacted this law, one can say that it includes much more sophisticated or balanced mechanisms of checks and balances with regard to the various measures that can be taken according to the law. For example, declaration of a terror organization, which is a very, very instrumental thing, because once you declare organization as a terror organization, there are immense consequences for the organization and for the individuals connected with the organization. So declaration of an organization as a terror organization is still in the jurisdiction or power of the Minister of Defense, but it has to be made upon recommendation of the head of the General Secret Service and the approval of the Attorney General. It's not consultation, it's approval of the Attorney General.
That was practice.
So then it was practice, but now it's entrenched in the law. And there is an appeal procedure, a new appeal procedure by a committee, headed 3 members committee, headed by a retired Supreme Court justice appointed by the Minister of Justice in consultation with the Supreme Court President. So again, the government really, if things will deteriorate here completely, the government can abuse the power. But if you have to go through an appeal committee, which is headed by retired Supreme Court judges, which is appointed in consultation with the current Supreme Court President, okay, this is likely to be an impartial or objective appeal committee.
Of course, again, you could say, I don't want to, but this I think is important. On the one perspective, you could say, well, we are moving in the right direction in the sense of more checks and balances. But conversely, you could say it's a protection mechanism for the government. Why? Because to the extent that, as you said, everybody realizes the Supreme Court sitting as a High Court of Justice is going to be there, to the extent that you have the vetting of this body, which is going to be more pro-government than the Supreme Court, one would assume, because the government has great control over the selection of its members, then the Supreme Court will find it more difficult to intervene finally in the decision, and therefore it's an interesting institutional mix.
One can make this argument, as well as the argument, of course, that this legislation not proceed any more than a regular legislation. It's a regular legislation. Yeah, there are pros and cons, but I think it's important to bring the factors. Okay? The counterterrorism law includes a penal section, okay, where the offenses now more distinctions between different associations with terror organizations, from heading a terror organization, managing a terror organization, membership in a terror organization, providing support or funds to a terror organization, training, expressing support, and failing to inform about terror organization activity. And as you see, the maximum punishments are much less severe than the old legislation, but that's still quite severe, from having a terror organization 25 to life, depending on the variety of activities conducted by this organization, to expressing support in a terror organization, which can impose up to 5 years in prison. And here again, there is a small check and balance mechanism that every indictment according of expressing support to the organization has to be approved individually or private. It has to be approved by the Attorney General in order to balance consideration of freedom of speech. But the law includes also a new methodology, which I think is very worrying, which I don't think that anybody really talked about it yet. On top of these offenses, which are sui generis offenses do not exist in the penal code, you have a definition of offense of terror, which is any offense committed with a specific intention. The intention was national, religious, or ideological motivations meant to create fear or panic among the public, or in purpose to compel the government or others, or to take or refrain from taking particular action. So, what was dealt with in the past by the Israeli Supreme Court, whether terror activity can be regarded as terror activity by an individual person without an organization, so forth and so on, this is solved by this definition, that every offense, if there is a special motivation, will be regarded as an act of terrorism. So a theft, a burglary, if the intention was as such, can be regarded act of terror. And of course, what the meaning is that the procedure, the penal procedure, the criminal procedure is compromised. We have privileged evidence, the arrangement that I talked about before. The government can present evidence that the defendant cannot attack. In certain cases, hearsay is admitted. There is no limitation, lifting of limitation. People can be in custody before judicial or hearing up to 72 hours instead of 24 hours according to the regular criminal procedure, right? And this can be manipulated. Okay? If a person is arrested for a theft, and there is a claim that this theft was an act of terror, okay, in principle, this person can be held 72 hours in his trial, disclose evidence, and so forth and so on. And this contaminates.
Attorneys also. Attorneys is actually 21 days. Not meeting with an attorney.
Yeah, which is a significant issue. So basically, what we have is an example of one of the general weaknesses of the business as usual model, that the emergency atmosphere and the emergency environment basically takes over to normality.
Is there a definition of terror?
Yes.
What is terror?
Yeah, there is a definition of terror.
It talks about fear, inflicting fear,
which is connected to act of terror. As I said, any action that is motivated to create fear or panic among the public, or in purpose to compel the government or other authority to take or refrain from taking particular action. Basically, okay, I'm sure that the Supreme Court will strap this down, but if a person is wants to change the government policy with regard to housing and demonstrate or captures property, this definition can be applied. Maybe the court will say this. No, but you're right. But the definition is quite broad. What the law, the new law said, I will get to my conclusion in a second. The administrative measures that the law enables, there is a very extensive section with regard to property, which is on one hand much less draconic than the old regulation, and in this case also many regulations from the defense emergency regulations were repealed, abolished, or will be abolished as for the 1st of November. But it has a very broad definition of property that can be confiscated, property that facilitated terror activities or used as rewarding terror activities ex post. There is a possible review of an administrative court, but again, the procedure might be more checked and balanced, but the scope of confiscation of property is quite bigger than in the old legislation. As you said, it copied the 2005 Financing of Terror law. The law didn't touch the harsh administrative measures that still remained even in Israel proper, that I mentioned before, like demolition of houses and restricting orders. And of course, this law also applies only in Israel proper, on the territories, and the harsh measures of deportation and detention are still in force. And what is interesting that the law did not repeal the detention law, the 1970 detention law. 1979 detention law, which is in force only during declaration of emergency. So this might be the good news, that if the government will not think, oh, we made a mistake and we have to entrench this law to final normality, and emergency will be abolished, then there will be no administrative detention within Israel proper. Okay. So to conclude, I would say that Israel generally maintains the formal facet of the rule of law under extreme conditions, specifically under extreme conditions created by threats of terror. And it uses the combination of emergency constitution and business as usual, with a shift to the latter because of the fact that the new counterterrorism law is going to be normal legislation and not only times of emergency. However, it did really touch the very, very sensitive parts, or the draconic parts of the defense regulation. So it didn't go as far as really repealing what I think is perceived by many as the most crucial human rights violation around the Arab conflict. And the third point is that the courts, and I didn't have time to elaborate on this court's decision, these various courts, especially the Supreme Court, assumed a very, very active role in the actual implementation of counterterrorism law. And not always successfully, as you can see with regard to house demolition or some deportation cases, but I think that this is a very important ingredient of the Israeli corrective Israeli anti-terror law characteristic. In a sense, the new counterterrorism law imitates the American and the British, maybe the Canadian, I don't know about the Canadian legislation. And of course, there are a lot of policy or normative questions whether counterterrorism law should be regarded as part of the rule of law under emergency or should be part of regular legislation, to what extent, maybe different parts of it, so forth, so on. And of course, in the more general area of the models, the possible models, what are the pros and cons based on the experience of Israel, what are the pros and cons of the different models, and where maybe we should resort to the prerogative model, business as usual, constitutional emergency, and so forth, so on. These are questions that we might address, or some of them, in the course of this workshop. So I will stop here and will be happy to hear 2 or 3 questions. We can adjust a little bit. I know that I'm 10 minutes extended my time. If there are any remarks, comments, questions?
Maybe very briefly, I think thank you, Eli, for this thorough introduction and also historical perspective. I think that we see the dilemma here of the legislature. I think what Eli basically is telling us is a story of 3 themes. The first theme is the dilemmas of the legislature. The legislature wants to think of itself as a democratic legislature, cares about human rights, but on the other hand, there is terror. So you could do one of 2 things. You can define terror very narrowly and then give greater powers. Because if terror is defined narrowly, then you can say, okay, if it's really terror, then okay, we can release the hounds and then we can attack them. But then there's a problem because you can address less issues. Or you can define it more broadly and then limit the powers of the government, or include more checks and balances over each power, which is what Israel is. So you broaden the definition, you include severe powers but less severe than were before, and you include the bureaucratization of these powers. You have to apply to this agency, and that agency, we have to be reviewed by this and by that. Okay, so, but it's a dilemma. Okay, so the first dilemma is how to deal with this legally. The second dilemma, I think, has to do with the story that it tells us is what do we think about the rule of law that relates to the question. Here, I think, what I learned from this is that as far as the formal rule of law, Israel is very clear. Everything has to be legalized. Even though within Israel there were some who said, well, let's not legalize it. Let's leave something beyond the law, outside the law. But it's not it. The question is,
we have an interesting example from the last decade.
Yes, exactly. You have a culture of illegalism. The court reacted, but de facto what happened? The court may react. That's the third dilemma. I'll get to the court. That's the third one. So the second point has to do with what do we think about the rule of law. So the formal question is whether we have a legal structure, or whether we just say, okay, we're going to step outside the legal structure. But the substantive question is more interesting. And Eli proposed one way to think about substantive rule of law, which is separation of powers and commitment to human rights. These are the 2 basic ingredients. There's a different definition of substantive rule of law that talks more broadly about justification. And there are 2 prongs to this definition. Justification is a positive measure that something is justified to the extent that the population thinks it's justified. Right? So positive justification. And there's a normative justification saying, okay, it could be justified to the extent that there are normative reasons, only reasons, and we don't evaluate the reason necessarily under liberal conception of human rights, but there got to be reasons that address some form of moral theory. Now here you can say that communism is also a moral theory that actually views rights as the enemy and not the answer. Kindness and other thinkers view that, and then it can be justified to talk about Russell. It can be as long as it is justified under some political theory, not necessarily the one that's about separation of power and right, then substantive rule of law is met, and Rawls in his, some of his work about bargaining with the type of bargaining that we should do with non-liberal regimes, talks about the dilemmas. So I think this should interest us, because terrorism, what you mean about terrorism, and I'll be brief about that, is that it uses, all terrorists view themselves as freedom fighters, right? That's the point. That's where it comes from. Nobody says, okay, I have a right to be a terrorist. Lehi didn't say, we want to kill people because we enjoy the process of killing them, and we have a moral right to go and kill people because we think it's fun. People say, well, these are measures that are required because of the oppression and because of the violation of our rights, because of the... Okay, so then now the question is, how do you tolerate those issues? And this is why the question of substantive rule of law matters, because the state itself uses illiberal methods to deal with an illiberal activity, but both apply to a grander normative justification. The state applies to, or the state applies to the normative theory of we gotta defend ourselves, and then the terrorist applies to the normative theory of we gotta claim our rights against oppression. The third, very briefly, the third point that I take from Eli has to do with the institutional design and the judicial review of the Israeli story. Judicial review. Here it's very complex. I think it's interesting. On the one hand, I think Eli very acutely and correctly described the Israeli scenario under which the court is present basically everywhere. You don't have, I think Israel is unique in that sense. You don't have issue with fiction. You don't have things that are beyond justiciability. Everything is justiciable in Israel. Standing is very broad, and basically you can go to court any time with respect to anything. De facto. The question then becomes how the court manages its discretion, when to intervene, with respect to what to intervene. Do you have, and here the dilemma is, do you have two distinct doctrines? This is the doctrine for emergency, judicially speaking, and this is a doctrine for normal time, or you have the same doctrine. And if you have the same doctrine, do you apply it differently, saying, it's the same doctrine, but under emergency, the value of these features within the doctrine changes, but the same doctrine. But if it's not an emergency, we apply the same doctrine differently. And we see the court not being coherent. If you really look at the cases, there's a terrorism case, and also all kinds of belligerency. The court is not coherent. Sometimes they say it's a different doctrine because it's emergency. Sometimes they say the same doctrine but we apply it differently. Sometimes they say it's the same doctrine and should not apply it differently because something is different here. And there's always a risk, and I pointed it to a crossover. And I'll finish with this. We see with respect to the right of fair hearing. The right of fair hearing was established in Israel under administrative law. There was a case of deportation. The right of fair hearing
And though it is very broad, indeed, the question is how do we apply it? Not only how do we interpret it, but also how do we apply law theft? And now it is true that in theory, every act of theft may be used this way, and the NSA has done similar things in the US, but doubtful if someone would pass something like that past the Israeli Supreme Court. So I don't know to what extent this is a substantive concern of significance. So what I just wanted to say is that I think there is also another checks and balances system that is in place, whether or not we want it or we don't want it. There is another way to go about provisions of this law.
Very interesting remark. Maybe 2 or 3 points in response. First, from a very formal Keynesian perspective, international law that is in fact in Israel is customary international law, which has direct effect, and international law that was approved by the Israeli legislature. But on the grounds, we see from the 70s much more use of international law, even as an interpretive guideline, even if this part of specific international law was not incorporated in the Israeli legal system. So there is a trend of the Supreme Court to take into account international law. Second point is that international law is very vague in many of these issues. So you can, take this and take that, and international doesn't solve all the questions that are confronted by these races. Third point, which I think is important to say, that both the courts and more important, the government wants to avoid the situation that it will have to answer in international tribunal. So there is a political science game here, okay, that the government will always restrain itself, as well as the court will give the correct reasoning in its decisions that will be on the threshold of the international community or the international courts, enforcement community, to say, well, they have sufficient procedures, independent institutions to enforce international law in the domestic courts without resort. No, there was a piece in the paper 2 days ago that the government is going to allow the special prosecutors to come to Israel and to the occupied territory. This is a change of the Israeli government policy. And I think this is in line with this kind of a game, that the governments will never cross a border that will bring it to be defendant in international tribunal, or the government is a government or specific in the region. So I think that these are 3 important components that first can explain the increasing utilization of international law in principle in Israeli, and the judges also. There's also a thing of the international community of democratic judges. The Israeli Supreme Court judges meet every year. Judges of the Constitutional Court in Germany, there is an annual meeting, and they're meeting the British Supreme Court justices, and American, Canadian, and exchange. There is something in the last decade of creation of this judicial elite that Israeli judges very much want to be part of, and this, from a political science perspective, will prevent them from, crossing the lines, one can say, that will bring Israel to the international tribunals.
One short comment on that. You mentioned international tribunals and courts. I don't think that Israeli authorities are that great for international courts, because basically we're talking about the ICJ that doesn't have any ability to do anything with Israel, and the ICC, which deals with war crimes which are not related to this mechanism. But on the other hand, we do have the review mechanism within public international law, the Human Rights Committee, and we have the Human Rights Council, which is a universal periodical review. So you have different mechanisms that will overlook the Israeli fulfillment of international law and make sure that, and rebuke Israel for the use of this kind of legislation or even the enactment of this legislation, even before see it in practice. So we have some kind of overview mechanism that will ensure that Israel, well, not necessarily ensure, but overview that Israel use. So not necessarily the courts, but the other mechanism. Okay.
Any other? So, oh, we are.
We're going to take that into account in the building of the framework. So let's take a short break and then reconvene and start the section.
This one or?
יפה. עכשיו זה אנחנו עושים.
רגע, עכשיו אני אחזור אותך. לא, עכשיו כבר.
I can send you a conceptual paper with all these questions.
ואין הסתייגות. That might actually be something to look at without having to do interviews. Yeah, I'm just thinking about the whole data.
שאומר ככה, צריך לתת את זה.
I think especially in Russia, the gaps between what is written in the statutes and what is on the ground is very, very crucial and significant. I think it should be difficult to avoid.
We know, for example, if we have data that judges in Russia receive notes, written notes, and somebody may agree. So the law may say one thing, and it comes to the judge, and the judge receives something.
Well, yeah, but I think this might be another way of conceptualizing or one way of actually conceptualizing this strategy.
It depends on
Which I have
what
studied for.
you're looking at. If I understood correctly, you are debunking the hypo that says the more authoritarian you are, right? That's the
Starting point.
right.
The
less you care about legitimacy, and then you say you still care about legitimacy.
Yeah, I'm saying they basically different legitimacy
That's right.
mechanisms
That's right.
works differently.
So exactly. So the conclusion is, so it works differently. But I don't think anybody really seriously states that dictatorships do not care about legitimacy. Dictatorships, of course, we care about legitimacy. Just a different mechanism.
Both the internal and
Excellent. Exactly. Assad in Syria relies on legitimacy. To the extent that his legitimacy failed, then you have a civil war. To the extent that his external legitimacy fails, you have intervention from the outside. And then what keeps him alive is the interest of Russia, that he doesn't have. Of course they rely on it. It's just not accountability in the democratic liberal sense. I don't think anybody seriously would say that any regime can last more than a decade or so, relying fully on, or even North Korea, which I think is the most extreme example, employs mechanism of legitimacy because they identify places. Otherwise,
Authoritarian mobilization.
yeah, otherwise the Machiavellian, the basic Machiavellian understanding that you can't apply force over everybody at all times.
your terrorism, both Russia and China, made pillars of legitimacy internal. That's so powerful that even if it can
The pariahs, yeah, even if they
Putin is not regarded as legitimate, international. What is important internally. This is interesting. Talked by the ex-Polish foreign minister, and he said, Putin had an agreement with the people. Their social contract is as follows: you allow me to be as corrupt as possible.
It's really cool.
And I bring you economic prosperity.
And stability.
Now, he didn't deliver economic prosperity in Russia. So he changed it to national pride. And all these Ukraine, Syria is kind of cultivating national pride.
But it's also stability in Russia, because the Russians, after the collapse of the war, and then Yeltsin, and there was a period of instability in Russia, and people in Russia were not so sure whether, and he said, look, communism is off. Democracy was not ready for democracy because it's destabilizing. Democracy isn't destabilizing.
It was an idea.
It's an idea.
Never had reason.
Democratic countries. So I bring you stability. Stability, some form of prosperity, decent, and the national private sense should be better. And
But this actually means that, for example, if you would think that there is a need to capture for internal purposes, you need a very, very strong external measure, deterrence, to protect. If you think that, there might be a revolution against him from within, then he will give a hand with the even for members of NATO.
Yeah.
The situation in Europe is going to be interesting.
So far, it just doesn't even say there's no real reason.
Ja, aber das haben wir schon alles gesagt.
The incentive is very popular.
No, ich meine,
The Ukraine would have been. But this is not which is great.
More active, but also more,
Legitimacy, you also have a very offensive stuff. That which the public uses as legitimate is just a pure fact. You either look at it or you don't, that's it.
But it's also being affected by what you want to say. I mean, if they're actually trying to move that.
It's a fact that is important by law.
Okay.
So this middle ground very rich liberal democratic theory that includes in the world, Russia, China, in Africa, in Asia. But you have this middle ground.
No, I didn't want to.
There's nobody to be justified, even though public realizes that yes, you want at least they have something that informs the fact. Layer, it's not necessarily a person but it's not access to so this is what I
All response.
then you can relate it to the rule of law.
We'll talk about
just prepared like the examples so we have the particular data. The lots of we don't have this type of facilities. So I would like first to thank So the organizers, it is a great honor to be a part of this workshop. Now repeat my first sentence. Let's begin. So my paper addresses the question of whether countries should be required to invest financial resources in order to minimize harm to civilians among other countries, mainly civilians among the enemy. I started thinking of this topic back in 2014 after the ending of Protective Edge Declaration, which resulted in severe damage to civilian population in Gaza. And despite of the massive attacks in Israel, the damage to the civilians in Israel was relatively low. So the relatively minor damage was naturally ascribed to the better defense facilities Israel has, such as safety rooms and shelters, but it was mostly attributed to the Iron Dome missile protection system, which proved to be rather effective. So the gap between the harm to civilians among Gaza civilians and the gap and the damage to Israeli civilians invoked several claims and accusations of disproportionate attacks initiated in Israel. And it triggered a public discussion whether Israel was legitimate in initiating war, given that only defensive war is permitted, according to the main claim. The minor threat to civilians should restrict its permission of initiating war. When I introduced my friend this claim, the first reaction was to say, yeah, it's true, but it has to be remembered that Israel has invested money and other resources in acquiring and developing such systems, money that could have been otherwise invested in other ventures, including life-saving ones. And when calculating proportionality and legitimacy, what should be counted is it's not the actual harm, but rather the harm that would have been caused if Israel not invested the money in those systems, or at least we should count in the lives that could have been saved and the money being invested in these other life-saving ventures. So I find both the initial claim against Israel as well as the first reaction quite weak.
Sorry, I missed.
The countries have a right to defend themselves, and this right includes not only the right not to suffer losses among the civilians, but also not to be attacked, almost regardless of that. Not regardless, but not to be attacked, even when the actual harm is low. This is so especially when the attacks are massive and disrupt the routine life of the population, like it happened in Israel during the summer of 2014. However, it seems to me obvious that what should be counted when you calculate proportionality is not the hypothetical harm, but rather the de facto harm. It's hard to justify acts that entail massive collateral damage to civilians when the threat to civilian states initiating those attacks is so low, like claimed to be in Israel. So there should be some kind of relation between the degree of the risk to civilian population and the massiveness of the attacks the state is allowed to initiate. So, but this principle evoke related questions, which bring us to the area of how states should distribute the financial resources. If the existence of such a system means that when such a system exists, the attacks are less harmful, so that the better states are shielded the less harmful attack they initiate, maybe there is room to demand countries to shield themselves with such systems, not only for the sake of protecting their own civilians, but also for the sake of protecting or minimizing harm among other countries' civilians, especially among the civilians of the enemy. It might be helpful to think of this demand from a different perspective if we consider the principle of necessity. So according to this principle, in order for an act of war, for a harmful act of war to be permitted, it's not enough that collateral damage would be proportionate with relation to the goal it seeks to achieve, but it also needs to be unavoidable, meaning that there would be no other less harmful option to achieve the same goal available. So under this principle, it seems reasonable to demand countries to shield themselves. So that there would be no reason for them, or at least a lower reason for them to initiate massive attacks. And we might also want to demand of them to acquire and develop other harm minimizing tools, such as sophisticated weapon systems and smart missiles. So, when discussing the principle of necessity, sometimes it evokes the question of whether countries should risk their soldiers in order to minimize harm. So, according to the principle of necessity, for example, even if the collateral damage anticipated to be caused by an aerial assassination of a terrorist defined as a ticking bomb would be considered proportionate, if there is a ground operation available that would cause less harm to the civilians, it might be the case that the aerial attack would no longer be legitimate, no longer be proportionate. Well, that is so even if the ground attack is anticipated to cause more risk, to impose more risk on soldiers. What degree of risk and under what conditions? Sorry though, but there is no agreement, and I do not address this question here. But in general, I think everyone agrees that some kind of risk should be taken. But if this is so, if we demand countries to risk the soldiers in order to minimize harm to civilians among the enemy, shouldn't we first request that they would invest money for the exact same end? So in my paper, I claim that we should. But I also claim that we have mixed intuitions with regard to this question, and that while we think that the necessity condition does impose a duty on countries to invest financial resources for the sake of minimizing harm in civilians, we differentiate between the way states are allowed to consider to balance between their internal interests and the interest of minimizing harm before the war started in acquiring and developing this tool, and the way states are allowed to weigh such considerations once war is begun, the tool that already exists. So, to illustrate, let us consider these two examples we have. Okay, so the first example happens before war. I've told it for a while. So at an Israeli government meeting, the intelligence officer presents a prediction that a war will start during the summer. He further informed that the expected loss of Israeli civilians will be significant unless all tunnels in Gaza are destroyed. Destroying all tunnels is anticipated to result in the death of many Palestinian civilians. But this will still be considered proportionate. I mean, damage to Palestinians. However, should Israel purchase more smart missiles, it would be able to reduce damage to Palestinian civilians, as such missiles are much more accurate. The cost of such purchase, however, is very high, as purchasing the additional smart missile would force a parallel cut in the budget, such as cutting the budget of the healthcare subsidies, leaving out a life-saving drug for cancer patients. Summer has come, the intelligence officer was right, the war has begun. Now a fighter jet is about to destroy a terror tunnel. The aircraft is armed with two kinds of weapons, a smart missile and a simple one. The smart missile is able to destroy the tunnel with relatively low collateral damage, but it is also much more expensive. It is critical to Israel to maintain a certain amount of smart missiles. Thus, once the smart missile is used, such missile is missing from the essential arsenal, necessitating the purchase of yet another expensive missile. While in the air, one of the pilots recognizes a number of civilians standing next to the tunnel. The pilots predict that using the simple missile would result in collaterally killing the civilians. The death of the civilians, however, ignoring for the moment the existence of the smart missile, would still be considered proportionate in relation to the military advantage of destroying the tunnel. So the question is, how should the agent in each of the cases act? That is in the first case, that Israel have a duty to go in favor of purchasing the extra smart missiles, although that would mean to cut the budget of the healthcare, or is it entitled to prioritize the interests of their civilians first? It has to be remembered, as said in the example, that in the absence of the option of purchasing extra smart missiles, the damage to the civilians among Palestinians would be considered proportional. And what about that pilot in the second example, do they have to use a smart missile, trying to avoid or to minimize harm to the civilians this far, or they could also consider financial considerations, deciding to save the money. So as I said, I think that we differentiate, that at least intuitively, we answer differently to each of the cases. I think that while we think that states do have, that Israel does have a duty to invest financial resources and states do have to consider this, to weigh this consideration. In the first example, it might be the case that Israel is not obliged to vote in favor of such purchasing, and it might be the case that it's allowed to prioritize the interest of expanding or not cutting the healthcare budget. I think while that, in the second example, we think that the pilots are not allowed to weigh such financial considerations when supporting the civilians, and they do have to use the smart missile, even though it's much more expensive, and even though they know that it has to be replaced in a new one. And I think that this is so not because of the difference in the cost. It's not because we think that in the second case it's only one missile. The first one seems to us to involve much more a greater cost. I think that it would be that our intuitions would not differ, even if we assume that the costs relevant are the same in each of the cases. But if that is so, of course, we can stop here saying that we don't share this intuition, but assuming that we share this intuition, it's a bit puzzling, since in both cases, the reasons to be considered are almost similar. But in both cases, the question at stake is whether Israel is required to invest financial resources in order to minimize harm to civilians in Gaza. And in both cases, in the absence of the other option, the damage to an anticipated damage to civilians is considered proportionate. So what can explain the gap should such a gap exist? So in my paper, I present two accounts that might explain the gap, and I reject them. The first account is which focuses on the distinction between statistical lives and identified lives, claiming that we tend to attribute more weight to the purpose of saving identified lives than we do to the purpose of saving statistical lives. And the other account focuses on the legitimacy of the claims that potential victims in each case may have. So I reject these two accounts, and I offer an argument according to which the gap between the cases is better understood on the ground of the distinction between the state's duty to protect enemy civilians and the state's duty to avoid harming enemy civilians. This distinction is related to a wider distinction articulated under the doctrine of doing and allowing, broadly speaking, according to which other things being equal, doing harm is worse than allowing harm to come about. And this distinction, too, is often being discussed when considering the duty of a country to risk the soldiers in order to minimize harm to enemy civilians. So some writers claim that we sometimes tend to introduce a dilemma in a misleading way, asking whether a country should be required to impose risk on the soldiers in order to protect the enemy civilians, instead of asking whether countries should impose risk on the soldiers in order not to harm the enemies. So while one may claim that countries do not have a duty to protect civilians other than their own civilians, the same claim can be raised with regard to the duty not to harm civilians. We know that the duty not to harm civilians is well rooted in the IHL principle as well as the just war theories, ordering countries to distinguish between civilian violence and allowing attacking only military on the back. So let's go. So generally speaking, this is made clear that the gap between the cases is related to the gap between these two duties. So let us go back to the examples and see how this distinction applies. So I'll start with the second example. So while in the air, by choosing to fire the simple missile instead of the smart one, the pilots themselves, at the moment of firing, killing the civilian. So the duty to use the smart missile instead of the smart one would be the duty to refrain from harming civilians. yeah, and first example, on the other hand, by voting against the purchasing of smart missiles, Israel does not harm anyone. It merely refrained from taking actions that would enable her to refrain from harming in the future. But at the moment of voting, nobody is being hurt, and at the moment of voting, Israel is not harming anyone. So the duty to purchase more smart missiles, if it exists, would be our duty to protect and civilians, or something more close to protection duty than it is to not killing. So, but even if that is true, and even if my argument shows that the cases of each case is dealing with a different kind of duty, maybe even a duty of a different way, it still doesn't explain why it's not the case that in both cases the duties apply. And why don't we say that, okay, it's a different duty, but still Israel has a duty to take these actions? So to answer this question, we need to recall, the consequences of purchasing extra smart missile and then the consequence of using the smart missile while in the air. So as it said, and in order using those missiles, purchasing the extra smart missiles would require Israel a parallel cut in either end. In our case, it would require a cut in the healthcare gap project. So the duties towards the civilians among the enemy have to be weighed against the duties Israel has towards its own civilians. In our case, its duty to supply its civilians with the best healthcare possible, which is a kind of duty of protection. Not by expanding the healthcare budget, as well as kind of protecting its civilians, or even not precisely protecting, more in that area. In the second, in each case we have to weigh the duty that Israel has towards its civilian in Gaza versus the duty of protection. So in the first case, while voting, as we said, Israel is not harming anyone. We can argue about it, but we can argue about it whether we can actually define the duty to purchase more smart missiles and the duty of protection. But what I'm trying to say in my paper is that whatever voting in favor of purchasing more smart missiles is, it is different. Whatever voting against purchasing smart missiles is, it is different than harming the civilians in the way the pilots harming them. So you might not want to call it a duty of protection, but I think we can agree that it's different than the duty not to harm in the way the duty applied in the second example. So in the first case, when we balance between duty Israel has towards its own civilians, which we say is a duty of protection, versus the duty it has towards its civilians in Gaza, it is a duty of protection versus a duty of protection. And there's excessive arguments of national partiality. I'm not going to get into it, but it is commonly assumed that other things being equal, states are allowed to prioritize the interests of their civilians before the interests of other countries' civilians. So when you balance between the duty to protect Israel's civilians versus the duty Israel has to protect the civilians in Gaza, it might be the case that Israel does not have to go to protect the civilians in Gaza. And in the second example, on the other hand, the duty that the pilots have to use the smart missiles is the duty not to harm the civilians we spot. So the balance would be the duty to protect Israel's civilians versus the duty not to harm the civilians in Gaza. And when this is the case, things are no longer the same. Things are no longer equal. So it is not clear that Israel is allowed to prefer the interests of their own citizens. So to conclude, I think that this is what best explains the gap between the intuitions we have towards each of the keys. We all think that the duty to invest financial resources should be part of the duties, the principle of necessity imposed. But we still think that countries have a right to weigh the interests of their own civilians. So it will always be the case of the country's duties towards the other worlds. In the case I deal with the duties country has towards civilians of the enemy versus the duties country has towards its own civilians. So it's the difference in the balancing between the duties that grant the difference in the intuitions. That's it.
As a formal respondent. Okay. I will try to be very brief, but adjust my response to a workshop style presentation and not a lecture, because I think it's an interesting paper with a lot of insight and should be brought to publication, so this is in mind. First of all, the question deals with the question, like, do states have a duty not to harm or to protect other enemies, civilians, before and during war? Okay. The title of the paper doesn't reflect this. Okay. When I heard, when I saw first financial consideration during war, I thought that something totally different. And even literally, if we're talking about before, or the comparison before and during war, and this is not reflected by the title. And also the first section deals with proportionality and necessity and various other things, and whether Israel was right. And until you phrase the question, you're almost third of the paper, and from a structural perspective, this is not good. So you have, I think, to revise your first section and rephrase the question properly. Second remark, general remark, is that it's totally unclear in various stages of the paper when you're talking about legal analysis or moral analysis. We talk about proportionality and necessity in the legal realm, the international law realm. We talk about other questions from a moral perspective, and you don't distinguish. I think it's important, unless you hold a very extreme view that law is morality. There is such a view. I think that it's important that we make this distinction, especially in Israel, when everything is justiciable, and law has an answer to every question. We have to know that law, the answer of the law is not necessarily the moral answer. So I think it's very important to make a clear distinction between legal obligations and moral obligations. A third issue connects to the general moral theory that you are trying to develop. You never actually articulate. You're talking about ontological morality, teleological morality, maximization of the common good, maximization of utility, maximization of wealth, financial consideration, welfare. Okay, I think it's important to talk a few words about this as well. I assume that you are talking about teleological morality, because you were talking about the general good and the balance between healthcare to our citizens and not harming the enemy citizens. So there is some teleological thinking, but I think you have to try to articulate it. Another point regards intuition. You talk that your baseline is intuition, and you want to explain this is a moral way, more philosophical moral way, Aristotelian basically morality. But in this case, intuition is, it's your intuition. You refer it to our intuition. And I'm not sure that we all have the same intuitive baselines. And since we're talking about issues, not even in particular society, but referring to international duties, so Chinese intuition, Russian intuition, Japanese intuition might be very, very good. So if intuition is important, you have to do some scientific work on positive morality or customary morality. There is a very famous case that the Israeli Supreme Court Justice Levin told me this, but I'm teaching this case for our jurisprudence class. There is a case of a totally different area. A case of a court was, the Supreme Court was asked by the state to declare a baby as that he can be adopted because
Without the consent of the parents.
without the consent of the parents, because his father and mother hadn't conspired. That the father, since the mother couldn't get pregnant, the father actually slept with a neighbor.
Mother and the wife.
Yeah. Anyway, the court, from a positive perspective, a formal perspective, it's very, very difficult to declare this child without the consent of the parent adoptable. But all the judges had this intuition, and they created some of them natural law, some of them very interpretive. When Shafran presented this case from French colleagues, terrorists, told me, "You are crazy. Our intuition is totally different. The best thing for the child is to give him his biological parents." So the whole construction of the court was constructed on this intuition, which somebody else from another culture said, our intuition is totally, moral intuition is totally different. So I'm saying, be aware of using so many times the intuition of.
Not to mention the intuition of the Gaza. That's
Yeah, what you do with the Gaza example?
I think it would go totally.
Well, I'm not sure about that because this relates to the next one. Okay. You mentioned, difference between between the proportionality in legal or international law and utilitarianism of working for the greater good. From a moral utilitarian perspective, you can talk about harming the enemy civilians from very, very other utilitarian perspective. For example, there is an argument, I think this is the real argument of the lack of proportionality between the Israeli casualties and the civilian casualties in Gaza. The Israelis think that from a utility perspective only of Gaza's citizens, it's much better to give them a very hard stroke now, because this will delay the second or the third or the next round. And from an only perspective of the utility of Gaza, of Palestinians, not taking into account Israel's happiness or good, it's much better to strike them hard now, and this will create peace for the next 5 years instead of peace for 1 year, and their situation is better that way. And so this is maybe a totally wrong, but this is a greater good or teleological argument, and so with teleological goals, for example, the time slots of calculation of the greater good is very important, and other issues which I don't get into the paper, and I think they are quite important. If we calculate the greater good for the 100 years to come, the calculation would bring very different results than if we maximize utility of the spot of time now or for the next year and so forth. Another point that from Israeli perspective, it's utility maximizing from only Israeli perspective to use smart missiles, to purchase smart missiles. Why? Because this will allow Israel greater targets, wider range of targets, because the collateral damage which will be viewed from international legal point as proportional, it will be smaller. So it is our interest to buy smart arms, and it's not at all.
But because it's your flag,
Okay, so this is another point. I will skip some points. I'll give you afterwards also some things that I wrote. But I think that the hardcore philosophical argument is quite interesting. And I think that there are two interesting points here that you have to elaborate. First, I think that the whole literature between statistical lives and identical lives is missing, is lacking. It's actually two different dichotomies. Identified versus unidentified, and probable versus certain. And if you play on these two axes, you get very different results. Okay? When a pilot is thinking whether to use the smart bomb or not, okay, it's statistical. It's still statistical. Okay? It's always, but it's identified because you know the people who are involved. Okay? And it's always statistical because there is, the case in which you have certainty, okay, from a philosophical perspective, maybe it doesn't exist at all, but let's say that 99.999% is certainty. Okay. And I think there is a difference between 0.0001% of a killing person and 99%. Both are statistical, but the differences are within the statistics. As well as we say, if it's moral to kill the first person who comes into a room, it's unidentified. Is it moral to kill someone who comes to the room? It's identified and it's not connected. So I'm not sure that I buy this identified versus statistical, and one has to work on it.
No, but the entire model, these things, the entire model.
Yeah. This applies also, I think, to your argument that relates to basically passive or active acts. Allowing or the duty to protect and duty not harm are basically, in legal terms, whether there is an active act or inaction. And I think that here you can actually study something, learn something from the law. The law doesn't distinguish. And the main point in the law is actually the intent. And I think this is, if you murder a person by inaction, it's still a murder because you have an intention. You could have done something. You could have done something, and the fact that you didn't do anything is equivalent to doing. If my moral intuition, some of us moral intuition, we regard this as the same thing. And I want to ask you if this is not the actual distinction line in your cases. Okay, if the government decides intentionally not to buy a sophisticated arm because intentionally it wants to kill more people, morally it's I think it's as problematic as the pilot decision to throw the simple bomb on the smartphone. Okay? So maybe the mens rea here is the distinctive characteristic and not the question of identify, not identify, or duty versus action versus inaction. Two last points. You're a bit manipulative when you talk about the question whether to buy smart missiles or to enhance healthcare. Every decision, budgetary decision, has life consequences.
What that was about the settlements, build more settlements.
Or I would say, if it's the set budget of the army that has to decide how to expand, it's buying the smart missiles or upgrading the cars of generals. Okay? So you can present this dilemma in healthcare versus, and this is connected to the partiality and so forth. Just to conclude, if you conclude basically that there is no duty of the state of Israel to buy smart missile, but there is a duty of the pilot to use a smart missile once he is on air. And of course, that begs the question, if you decide that Israel doesn't have the duty to buy smart missile, the pilot will not have smart missile. It is the second dilemma. So, in a sense, your answers to the two questions are in paradox with each other.
Thank you. So I'll start with the last one because
This is really correct.
yeah, okay.
Just for the second time. I'll try to make again very brief. I think that we should begin by asking what is unique about the case. One way to approach the very interesting question that you present is to ask ourselves what is unique about it. Is there something unique about this sui generis war, or is this the type of dilemmas that we face in situations outside of war? And of course, the first thing that comes to mind is in bioethics, the exact same dilemma. When a hospital is faced with the decision of which equipment to buy versus the decision of the doctor, the triaging right by the hospital bed, whether to take into consideration how much money the medicine will cost when I have to deliver a specific medicine or not. And we have a whole lot of literature on that. So I think the first thing to do would be to situate this dilemma. Is it part of a usual dilemma that we see between mass scale decisions by states, hospitals, institutions versus the decision by the individual on the bed? In which case, this is just one more example. Or is it something unique about war and the duty to protect others that is inherent about the situation of war? And I'm not so sure, because I don't think that the dilemma is so different than the dilemma of the doctor vis-a-vis patients versus the hospital, which equipment to buy. Because it's not clear to me that the type of analysis is so different. So
Partiality.
well, I'll come to this. So the question is this really, to the extent that I'm right, and partiality doesn't play any role. To the extent that I'm right, that the moral distinction is whether you talk about something that goes on between the doctor and the patient versus something that doesn't go on between the hospital and the general population over which the hospital is, or the Ministry of Health is responsible in one way or another, then partiality plays no role. So you have to convince me what is unique about this case that is not unique about it. Second issue has to deal with the notion. Suppose I'm wrong. So suppose partiality is the issue. Then there is a question of should we be partial to Gaza at all? Because, and this has to do with the example, because maybe we have an extra duty of care towards Gaza because Gaza is not really independent and we control everything that goes in it, and the reason they struck us because they had no food to eat, and blah, blah, blah. So there's a whole host of Gaza-related issues. I'm putting this aside. I want to focus on I think, two alternatives to this notion of partiality, other than doing an allowance. And so Eddie mentioned the third one, which is the dual impact, this notion that whether I want, the whole military ethical question of, do I want somebody to be killed, or I'm allowing, but not really, I'm going to kill that person because I want some. The doctrine of double effect. So the question is whether this is actually not a question of doctrine of double effect, it's with pilot. But I'm putting this aside because this goes back to the issue of intent, and Eddie covered the issue of intent. I don't want to. There are two other alternatives. One is relational and one is the remoteness, that are distinct from doing and allowing. The issue of remoteness under the philosophy of action talks about this notion of causality. So if I know with the same type of probability, and I have the exact same mental attitude towards something, so I'm putting all those two parts of the equation constant, I know that something will happen, but it's going to be remote from me. Then I'm saying, okay, I have less of a moral obligation under this notion of remoteness. Then if something I do is, the effect will be immediate as a result of my action. Okay, so that's the issue of, in the same time of doing. This is doing and this is doing, but it's the notion of remoteness. So maybe it's the notion of remoteness. Here I buy missiles and then a war might happen and this might happen. So there are several steps, and therefore it is not as connected because of remoteness. The second is the notion of relational. What's unique about the doctor, and I'll conclude here, what's unique about the doctor and the patient is, according to bioethics, is that the relationship has already been formed. And therefore, once a relationship has been formed, the doctor may not take other consideration, other than the welfare of the patient, into consideration. Now, clearly, you're not in a doctor-patient relationship. There is no doctor-patient relationship where the pilot is going to kill somebody, right? It's not the same problem, but it's still relational. Just the relationship is built differently. But once a relationship is established, under relational theory, this is what's doing the work. It's not partiality, it's relational. So you have two different alternatives. to the extent that we agree with your intuition, that deliver the same without all this business of partiality. You focus, and this is related, you focus on before and during. And that begs the question of what after. The question is, Eli talks about the relationship of the before and during, in the sense that if I don't do the before, then there is not going to be a dilemma during the during. But the question is that I leave you with is also the question of the after. Is under your analysis, the difference of partiality, is it just before war and during war, or is it also after war? Because Gaza has to be rebuilt, and people have to be, supported later. Can we still say, well, we have to take care of our own citizens, but we don't care or we have no real moral obligation to you after? Or once war has ended, something kicks in and we have this obligation towards not to be partial maybe, and to care about everybody.
Just like a small comment, because actually Wolf has said a lot of the comment, I would say just only a methodological a question or advice about the use of the Israeli and Israel and Gaza struggle that you want to, the way you want to use it, and the reason that you bring it as an example. Because if you're phrasing a moral question, then perhaps to be able to be more remote from specific example, particular parties is helpful to phrasing your question. Because naturally, if you're only interested in Israel and Gaza, then it's not really a research question. But once you talk about a specific case and you want to phrase it as a hypothetical case, which raises an interesting ground for a moral question, then I really can see why you still use a particular parties involved. Because to be able to judge the question clearly, you should be able to show that there's a broader dimension than the Israeli-Palestinian case. But when you give a hypothetical case with real parties, it is a little bit confusing, and for my opinion, it's that it undermines your purpose, because it sets like some mental boundary or mental obstacle for seeing the moral question that you want to raise. And actually, again, I want to restate something that Erin has mentioned. If we want to raise a moral question, then a hypothetical case is really helpful. But once we talk about the law, then a hypothetical question of drugs versus a weapon, when we know that in reality it doesn't present reality, it is less helpful, because the whole issue about law is trying to extract general cases from private cases from general cases. But we already knew that the case you bring has a very, very low probability to be a realistic case. Then the added value to our legal craft, actually, of shaping, of trying to know how to shape legal norms is really not so, it's low added value to that purpose.
Should I answer, or should we collect all of these?
Let's do a round of answers.
Yeah.
And
Okay. So I want to start with what bothers me the most is I think I didn't articulate right my conclusions, because I do not claim that Israel does not have a duty to invest financial resources requiring for extra smart missiles or other sophisticated weapon systems. My argument is actually very narrow. The only thing I'm saying is that from the national partiality point of view, the way we should or we allow countries to balance between their internal interests and the interests of protecting or not harming civilians among the enemy is differ between cases like the voting and cases of the pilot. But I did not say it, or I actually blame the opposite. I said we do think that the principle of necessity requires states to invest money. So this is just want to clarify. I need to check why is that not clear. So I have to be honest. Philosophical arguments are very different than like some of the comments I agree with, I understand, but excuse my words, but there is nothing I can do with them. When we do philosophy, we assume to clean all the psychological and intuitions that we have. It sounds funny that I'm saying that, but at the same time of basing my whole argument on intuitions, but we expect that to clear the table from questions of, yeah, but it is more probable. No, the pilots, they don't really think of the money. They think that it might be more accurate. No, the details that I consider are only the details that I gave. No other like probabilities that might be get involved in cases are now part of my game. So this is like a general remark, and I'm sorry to say that because.
So move away from Gaza.
Yeah. So okay. So this is exactly. So okay. So I'll mix my answer to the question. In my dissertation, I say almost no word about the Israeli-Palestinian conflict for exactly that's the reason. But I felt like maybe it is time for me not to run away from it. Maybe it's time for me. I'm an Israeli scholar. I'm sitting here. These are examples that the whole world know. It's true that we like questions of Israel's responsibility towards Gaza are getting bold, even though they should not affect the analytical argument. But I did it on purpose this time. But I agree with you. It's a risk. I took a risk, and maybe I was wrong, but I agree with the general. Okay. I do say something about the remoteness in my paper. I say that I think that it is part of the gap in the intuitions, but it's a bit hard to say because I also say that we attribute to an act more than the executive of the act itself. We say Israel killed Palestinians, even though there's no Israel that killed. It's not only the soldier who actually shoot the gun. So I think it is part of it, and I think it's the combination of the omission characteristic together with the distance from the moment of act that makes a difference in the intuition. So that I accept. And I reject the distinction between the statistical and eventful, like in this case. I think I don't want to dismiss the distinction at all. I think it has a great value for other questions, and I'm not sure I'm doing a good enough job to say why this is not the distinction that grants the discipline of intuitions. One word about intuition. So when I started learning philosophy, my advisor told me intuitions are a great way to start the discussion. It's never good enough to end discussion on intuitions. But to take away the intuitions as a part of the method of arguments is like I might go home. And the reason for it is that even if the conclusion of even if my argument shows the conclusion that our intuitions, it's not true that these are our intuitions. Sometimes it's good enough for an argument to show if we. This is of course if I pointed on an intuition, most of us share. If I was wrong with the intuitions, my argument is weak. But a lot of doctrines are starting with giving examples and relying only on intuition. It's not an empirical study. It's hard to run empirical studies in philosophy, even though there are some trying to do that these days. So I admit it. I said it in the middle of my presentation. If you don't agree with my intuitions, I didn't convince you. So my paper is not good. But also saying that it's valuable also to say that to show that these intuitions are wrong. And by the way, while writing the paper, it was hard for me to convince myself. So there was a moment where I thought, you are wrong. The intuitions are just wrong, and that might be the conclusion of my paper, that it's not true. But I feel that when I introduce these two cases, the first reaction of most people, it's not that it's empirical, it's a good enough empirical test, but I think everybody feels that the pilot has to fire that smart missile, but just with the first example, there is a disagreement.
It would be nice exercise this, by the way. Just to go.
Yeah.
And without the Palestinians. So it would be biased, yeah. That was,
All right. Okay, and that would bring us back to the question of whether it is unique to war. I said that this paper is not a part of the dissertation, but I was exactly accurate because I started thinking of this topic in the frame of the right or the reason to national partiality. So what interests me here is national partiality. Of course, the way countries should or required to distribute their financial resources is unique. It's a great subject, and but what interests me the most is the balance between the right to national partiality and the duties the country has toward civilians, toward other civilians. And I do not say it is bad if I made the impression that I think the national partiality is the kind of reason that trumps all other reasons. I think it has minor, I'm not even sure about that, but the only claim I have is that other things being equal, but really all things considered, other things being equal, the country has the right to defer the interests of its own citizen over the interests of other civilians. But it's almost never the case that other things are really equal.
Well, on the other hand, exactly the contrary. I think that national partiality is a very, very significant factor. Okay, we're not talking about wars and stuff like that. Okay? We invest our extra money in the welfare of the Israeli citizen and not the welfare of
Ghana. Ghana.
Yeah.
Right, but this brings us back to the distinction between doing and allowing. And I think, and I said that the distinction between the country's duty not to harm civilians and the duty to protect them is related to the distinction.
There is an epidemic in Ghana and in Israel. We didn't do the epidemic. Okay. Another question is, what do we do? Do we send our doctors to Israel or to Ghana?
Okay, so of course it's not a question you can answer like you can give a brief answer. But my perception
Very
is
brief answer.
Israel,
Very, very brief answer.
Yeah.
If the epidemic there is killing millions and in Israel only 2, then
But that's
Okay,
not
so-
all other things being
all
equal.
other things being equal, the answer is very straightforward.
Right, but the thing is that in reality it's almost never the case, and especially when you talk about refraining from harming civilians, it's almost always the case that it's the duty not to harm versus the duty to protect. Even when you send soldiers to war,
So you're not playing the game, you're saying. You can't
no,
play the game.
I'm saying it's very hard to balance between these two. But there is not. At the end of the day, you have to ask yourself what weighs more: the extra weight you may attribute to the right of the country to prefer its civilians, or the weight of the distinction between doing and allowing. But I think that the distinction between the two duties is related to the distinction between doing and allowing, but it's not all about it, because now I'm trying to say by the law, because I'm talking about moral principles, but I think also the law does not demand countries to protect civilians among the enemy. It demands countries not to harm them. So it is not only doing and allowing, and I think that the distinction between doing and personally, the distinction between doing and allowing apply, but also only when other things are being equal, and it's almost never the case that other things are exactly. And of course, and maybe I didn't say it precisely, but both cases are dealing with collateral damage. So the doctrine of double effect apply here, but it goes without saying. Nobody's talking about the direct and intended causing intentionally harm to civilians. It's forbidden. No question about it. The question starts when we talk about unintended harm, the collateral.
Right. But even within unintended, at least from a local legal perspective, there is a distinction between negligence and awareness. Which might be interesting to
Okay, it goes back to the men's right.
Yeah, to elaborate
Right.
your philosophical perspective, because you are
some of these collateral killings are a result of negligence. Some of them are a result of awareness. We know we don't intend to kill them, but we know that our actions
Right,
will kill
so-
them, and this is very different from negligence or we didn't really.
No, so I'm talking here about knowing, foreseeing, but unintending. It is hard. There are a lot of discussions around the double thing, whether you can really ground it. But I mean, yeah, there are these questions, and okay, I think that.
Especially the laws of armed conflict. You know, when it's not intended, which is collateral damage, it is allowed as long as it's not is disproportionate. But if you don't know that they are, at least ex ante, then you don't care about them, even if they got hurt according to the law. Moral issues we can discuss whether or not it's legal or not, but legally, you don't know that they are there, you don't count them.
But then, again, paradoxically,
There is middle yet, and in some cases, you should have taken
Shouldn't.
in order to.
Yeah, so this is like with the data discussion of double effects. It's not enough that you don't intend to harm, but you also have to intend not to harm.
Yes.
To take a positive steps to show that you have a positive intention.
But there are just a couple more questions here.
Yes, I want to hold on. Well, first of all, very interesting, more discussion. The way you now that we know it's more discussion, that it's journalist to me, because from a legal perspective, what actually is behind your presentation is different between the separation between this adverb and this inter. That's the and I want to comment here that you use terms that are taken from the INBEL definitions when you speak about things that are wide, such as we talk about armed attack, proportionality. Armed attack is use adult and attacks are in the definitions. Proportionality is different from both in INBEL and the adult. And the definition of necessity is it's not the Article 57 that you refer to. Article 57 as it's a precaution, of course, in attacks. It's not the definition of necessity in international law. And necessity, that's an interesting thing I want to tell you. One of the most, let's say, authorities for Max Planck encyclopedia says it is a definition for necessity. I read it to you from the hostage states in trials. This military necessity permits a belligerent subject to the rules of war to apply any amount and kind of force to compel complete submission of the enemy with the least expensive time, life, and money. So money is part of the considerations in this today. Theoretically, I think it's a very poor definition. I'll maybe address it in my presentation. It's a very weak, no one says it is, but I think it is. But theoretically speaking, the money is part of the equation as I speak about the IHL. Again, Article 57 deals with precautions of tax. It's very limited to tax, which is only part of the duty that we have in under IHL. And you have to be, this one I think that you have to, now, IHL and just walk theory will go hand in hand very short distance. And this is where the question for the justification of war as a whole, and IHL deals with the when you commence with what you case-to-case actually this is a very clear legal answer to what is the answer to the moral dilemma that you pose. The in-war is very simple. That's part of that's the case in the second. The first one, it may, for me as a lawyer, it has the opposite effect than you show. I think your presentation is a very good reason why to keep the in-law, the in-war road separate from the gray war or the justification of the war as a whole. You don't consider the total amount of deaths as something to begin with. It does not reflect any violation of law as next slide.
If I may say on the topic of Articles 57 and 58 of 81 and the application of precautionary measures, from a criminal perspective and strictly black letter law, I think that maybe a neater way to go about the argument is not through the principle of proportionality and necessity, but through states' obligation to take active and passive precautionary measures. Because states do in fact are under an obligation to take certain measures in order to minimize damage among civilian population. Now, IHL is completely agnostic as to questions of nationality and citizenship. The question is rather whether you are or are not a civilian. If you are a civilian from Gaza, from Ghana, from wherever, from Shangri-La, you are to be protected from the damages and atrocities of hostility. The state is obliged, when it is the author of an attack, to take certain measures in order to minimize them. Similarly, when the state is not the author of the attack, but it is attacked by a third party, say the other counter-belligerent party, it is nevertheless under an obligation to take certain passive precautionary measures so as to protect its civilian population. This obligation is prescribed under Article 58 and 81. So from this perspective, the fact that Israel is obliged to protect its civilians when it is attacked or when it is attacking does not necessarily conflict or contradict with this obligation to take certain active measures in order to protect the civilian population in, say, Gaza, Ghana, or India, or wherever. And in fact, these obligations, they are not absolute. They are crafted using benchmarks of feasibility and practicability and so on. And what this entails is not only military and humanitarian considerations, but also socioeconomic and developmental circumstances. So a state like the United States would be held to a higher standard to develop and purchase and use high-tech technology and so on. And this, of course, may be also justified for other reasons, from purely military considerations, because it is usually poorer countries that have larger armies, whereas it is the more developed countries that have smaller smaller armies but with higher technology and so on. So from this perspective, does Israel have an obligation to use smarter missiles? Well, the answer from an actual perspective would ipso facto be absolutely. Not only because it is a developed Western economy that has these means, but also because Israel is well accustomed and used to these kinds of conflict, and for this reason, it is obliged to use these kinds of circumstances. Nevertheless, I absolutely agree with you that IHL in and of itself does not prescribe any priority of how the state allocates resources. And this is only logical given the different duly applicable obligations. Some of them you have given an example of, and I absolutely agree with these examples. So these questions of how we prioritize the allocation of actual financial resources are questions of a different political, domestic legislation, and so on order. And it is, of course, very interesting to see how these are incorporated within IHL, but I would think that maybe a neater way to go about it and cut through the principles of proportionality and what is or is not disproportion is through states' obligation to take these precautionary measures.
Thank you.
Sure.
Yeah, I'm more or less covered for the YouTube, but yes, what I found a little bit, when you explained, I could see it was clear the points and the moral points and this kind of normative ethics and maybe a candidate. Then sort of the consequences of that. But what I found a little bit problematic is that taking from a very from a contained, very specific and oriented towards war, the legalism that it is about the conduct of the states, and taking notions from there and then apply them, abstracting them in a way and applying them in different contexts. you use this proportional idea out of the context of war. For example, for the pre-war considerations. And I know that it is the so-called proportionality principle is the compromise principle. Maybe it is an open door to many other considerations, just war and everything. But in terms of maybe black letter law or and not only that, it is still everything that applies from the moment that war has started. So this is what I found a little bit problematic.
Yeah. First, two remarks really. The first one regards, I think when I was reading the paper, I found it really interesting that I suffered from a total conceptual overload. And we were throwing all these principles at me, and I was like, okay, so which ones, where's she going to be running her thread through to building the argument? And I think what's implied in the comments is that you can run it a philosophical way, you can run it a legal way, but I think you might want to pick one or another, even for the sake of putting other arguments on the shelf, because there's only so many arguments you can treat in a single paper, so many concepts you can use. You can't always satisfy everyone. So probably you for yourself have to choose which one best reflects your intuition, if that's it. And the second point regards the cases. I don't agree with so much with you. I quite like the fact that you're arguing the cases because it makes it more tangible to me. But I would like to point you towards the difference between the cases that you've chosen, which to me reflects totally different actors. The pilot and the government, they are different agents. One is an individual agent, the other is a collective agent. They have different interests, they have different ways of...
different duties.
There's different duties as well. There's so many differences about them that even on a hypothetical level would make it very hard to compare them under a ceteris paribus condition. So if you want to stick with something tangible, and if you want to stick with the Israeli example, which I tend to be something at your very heart, maybe you can either compare different points in time where decisions have been made in the Knesset in the past, or you can choose different battles and go towards the individual actor level. I think it might aid your argument and also sort of streamline the concepts that you're using if you stick with one type of actor. And also, please scrap the US example. I don't see where it's coming from and how it's aiding the point. Which US example?
Third part.
But in the third part, there's been setting up the
president?
Yeah, and Israel being obliged to purchase smart missiles, and I just don't see where it's going and how it's aiding your point. It only really confused me.
Okay. Oh, okay.
That the use
Yeah.
the third part.
Yeah, okay. Okay.
So if I always like when I come across a philosopher talking about just war, because the whole notion of just war is to undermine the notion that the distinction of usable and usable, that otherwise you would stop at usable and from usable and we don't have any more discussion. You cross that border that we as lawyers usually place on the legality of the use of force, the legality of whether or not it's allowed to use in force, and what you do during a conflict. And when this current just war literature that I had a chance to read is breaking that notion of taking into proportionality and necessity forward than the border then withdraw and the different proportionalities that we address. But taking to Robert's point that comment that the definition of necessity that you use seems to be the definition of humanity, which is under our understanding, IHL is usually being considered as a battle between necessity and humanity. Military necessity and the desire to limit the damage to the civilians, or collateral damage or general damage from the conflict. And the entire necessity discussion of you have to limit is under my understanding based on the humanity. And when you place it under necessity, it's very confusing, both on ad valum and in the perspective, because yeah, you have alternatives. This is necessity of ad valum, but once you cross that line, I think you at least need to look into the notion of humanity would be in that context. And with regard to the use of the Israel-Gaza example, actually, I like it because, as I said, most of the writing about these issues is derived from a specific example. But it is risky, and it is risky because you're in Israel. And I once received an advice from one of my professors that don't write about IHL because you're in Israel. And when Israel is right about IHL, it's already, there is some perspective when people are reading that. So I'm sure that there are other conflicts, but I actually like the Israeli-Palestinian conflict and the use of taking.
We're so lucky that we get it. We can use it.
But take into account that it might come that we need to publish.
What is it like for me? No, better there.
If you talk to the Israeli-Gaza conflict, and then there is the issue of the law of occupation and all the range of obligations that.
Okay.
Yeah. So yeah, an aspect to it that's more internalized. The understanding of the law of occupation today, if the scenario would be that maybe obligations that arise in that context would apply to this case.
Just a note about the example. I think I don't agree with you in the sense that you can't take it both ways, both realistic and both hypothetical.
This is philosophical writing. This is what they do.
Yes, but once
The philosophical requirement.
No, but once you talk about specific parties involved, particular parties, you can't just distract it and then say we talk about hypothetical case. Because if you want to take a case, you will have to take the complexity of the whole of it, and not just to try to imagine the case.
Spoken like lawyer.
Well, you have lawyers.
One thing, there's a good article about the use of decision missiles weapons. So the legal analysis of it, Smart Schmidt, 2005. You mentioned it. I'm not sure if it
I cited all of Mike Schmidt in my paper, so you
can. But I think it leads to
It's good spend.
Do I have time to respond? Yeah. Okay, so that's a quick answer as to the different actors. So when I talk about the pilots, I talk about them as representatives of the country. They are the country. For me, like instead of imagining the pilots, imagine the pilots taking orders from the government, from a government. So maybe I should articulate it more clearly, but again, it's coming again to this general problem of course, there are millions of other factors that can distract the when we're considering these examples. For me to clean all the possible considerations of will come, it's impossible. But I might need to do it later. I'm worried about the in Beirut as well. So, yeah, in the paper I'm trying to a little bit write about it. I'm still not sure what my perception is to the distinction, the rigid distinction between in Beirut and Adel. I know still assume that these are two separated notions, but personally I feel that it's a little bit fake, especially when we discuss Israel. Nobody judges Israel from the moment the war has begun. It's always you always take into consideration other factors that if you really follow the distinction, you should. So, yeah, I do this. I do it the same when it comes to work. I'm working a bit more. Okay, and listen. If everything is possible, of course, so there is no question. Yeah, Israel should protect its own civilians. It needs to not to harm other civilians. If you can, it needs to send rice to third country civilians, to other countries. But in reality, it's always balancing. So I do think it is all comes down to proportionality, because it's always going to come to the question of, in order to protect my civilians, I need to do or not to do something to other. And to answer if I may do or may not do, it would always come back to proportionality. Yes, even if it's in Israel, there's like the overuse of the terms. I don't know how to translate to Aniyei Hakudmi, like the poor of your own country is come first. So I always say it's true, but if the poor of other countries are much poorer, so it might not apply. So it is. So for me, it always comes down to this to proportionality, and I think that the duty to use financial resources is under the principle. It should be considered under the principle of necessity. I need to talk more about it because I did my own research, and it is a philosophical, like I'm coming from a moral point of view, from a philosophical point of view, which is a whole different world. But we do talk to each other, and I think that we're trying. For me, if the law has no moral ground, so for me there's nothing to talk about. Like, so that doesn't interest me. But if I want to try to ground the law in moral reason, so this is where I come. These are the interactions that interest me. But
already tackling stuff of the immoral. Legal officer.
Great.
Time